consented or she was willing to get married to him. Your Lordship, when on repeated attempts of contacting, she said no. Your Lordship, at the time of dragging her into the vehicle, Akash, when he said let's get married in a temple, she shouted no. Your Lordship, it is
that should be your point. Once she said no means no. It can't be interpreted in either way. It's no means no.
That is the basic contention in this case. The rest of the story is something different.
May I proceed, Your Lordship?
Yes.
Your Lordship, as you said, no means no. In the case of Kanchana Sasi Krishna versus State of Andhra Pradesh, it was held that when the accused contacted the deceased repeatedly despite a clear indication of disinterest, it obviously attracts the offence punishable under Section 78 BNS, which was earlier Section 354B of IPC. Your Lordship, in another case of Ajay Ilangavan versus State 2023, it was held that repeated contact despite clear disinterest and the level of impact on victims' mental health or safety has to be considered by the court. It is further concluded that the cases stated.
Mr. Counsel, first explain this. In your case, you have pointed out that she said no, but the case law which you have relied upon, in that case, disinterest has been shown by the victim. You are on the better footing, or the case before the Supreme Court in which she has shown the disinterest?
The answer, I would believe we are at the better footing.
Yes. Showing disinterest, something else, but saying no, big no. Right?
Yes. Your Lordship, therefore, Ms. Anita's clear indication of no attracts the offence punishable under Section 78 of PNS. Furthermore, I would like to proceed with the essentials of Section 87, which is read with Section 3/5 of PNS, are met or not. Firstly, essentials of Section 3/5 are met. It is joint criminal liability. There should be a criminal act. First essential. Second essential, that act should be done by several persons. Third essential, in furtherance of the common intention of all. Fourth essential, each of such persons would be liable for that act in the same manner as if it were done by one person, as if it were done by all the persons. With the present case, we see Akash and Suresh, as has been mentioned in the Moot Proposition paragraph 5, they agreed that they will, even though she said no, Your Lordship, a major saying no, they didn't listen to her. Even though she said no, they agreed that they will go to her, but again trying to convince her to get married to the temple without any parental permission. Secondly, they also, Akash agreed on use of acid as a threat. That we will only threaten Anita to comply with her wishes. Your Lordship, even using acid as a threat, acid is no joke. Acid is not a playing tool. Therefore, even if Akash is saying that don't harm Anita, we won't harm Anita. Your Lordship, acid is not something to play with. Acid is not something that you are carrying with yourself regularly on a daily basis. You are not.
Why we are not talking about Suresh?
Your Lordship, in the present case.
Why you are not arguing against Suresh?
Your Lordship, in the present Moot Proposition, Suresh is already fled. Therefore, already fled. He is not in the state. Therefore, the case is against Akash.
Okay.
May I proceed, Your Lordship? Therefore, therefore, when Akash even agreed on the fact that okay, we will use acid. After this, any act taken in furtherance of acid use, he has consented already. He has agreed upon it. Your Lordship is a science teacher. Any layman knows what acid can do. May I proceed, Your Lordship? We cannot say that he was not willing to harm her. Even if he was not willing to harm her, he had knowledge to it. He had knowledge that this can harm her. Therefore, common intention. In the case of Hamlet versus State of Kerala, it was held by the Supreme Court that the ingredients of Section 3/5, Your Lordship, I am referring to the memorial of the appellants, 21 page, last paragraph. Section 3/5, that is, the accused had acted in furtherance of their common intention, is required to be proved specifically or by inference in the facts and circumstances of the present case. Your Lordship, on the day of 10th July 2019, as per the plan, they both waited for her to pass on the lonely road and approached her. When she refused to come with them to the temple, even then when she refused, Akash started dragging her. On which Miss Anita started shouting. Your Lordship, my friends in the respondent side may say that abduction, as has been mentioned in the essential ingredients.
Why are you putting your words in their mind?
Your Lordship,
Why are you expecting this? They will say this thing.
Your Lordship, I'm standing at attendance already.
And one more clarification. Here, perhaps Anita got injury. She was inflicted injury. That was a grievous nature. If in case she would have not inflicted any injury, then whether this Akash was again liable for that offense. If there was no injury of the acid.
Acid was not thrown? Or acid was not thrown or acid was thrown?
Acid maybe was thrown,
but no injury has not been inflicted upon her.
Your Lordship, still, there was a big possibility that this could have been.
That's not the question.
Specific query.
Specific query is that in case she would have not inflicted any injury due to acid, though it was thrown upon her, then your argument would be like the same.
Indeed, Your Lordship.
अगर उसको इंजरी नहीं होती है तो सुरेश जो आकाश है वो कैसे लाइबल हुआ फिर मान लीजिए फॉर इंस्टेंस इंजरी नहीं होती है उसको देन
Your Lordship, still the argument remains the same.
Why? There is no injury at all.
Your Lordship, we can say overshooting or misfiring as a case.
I think
before proceeding further, can you read section 3, subclause 5? Can you read?
The essentials of this act are there should be a criminal act.
Bare language of section 3. You are having this BNS with you? Yes.
When a criminal act is done by several
Criminal act. Yeah.
Your Lordship, if I am not mistaken, attempting to threaten a woman with acid attack, attempting to threaten a woman with acid in itself comes under grievous harm, grievous injury.
Then read that section.
No, okay.
Even threatening is act, then read it.
Section
124.
124.
Yes, can you read it?
Using or attempting to use acid or any other drugs.
Using or
Attempting.
Yes.
Thank you so much, Your Lordship.
First of all, if you want to go with some argument, then that's their definition must be clear. There is no need that injury is caused. Like 307, there is no need.
No injury.
Injury is caused. Intention is there.
Only intention should be there.
That is the basic concept in this acid attacks. Okay.
May I proceed with the abduction?
Yes.
Aram se, khushi khushi. No tension.
Take your time. No problem.
When I said abduction, there is because obviously abducting a woman is keeping her in your confinement. However, in the present case, there was no confinement. However, Your Lordship, forcefully dragging a woman without her consent, dragging her into a vehicle without her consent. She is an adult, she can give consent, Your Lordship.
Yes.
Therefore, even if the argument goes as such that there was no abduction, we cannot prove intention. Your Lordship, there was abduction. They had clear intention.
I think it is not abduction, it is kidnapping. What do you say?
Your Lordship, it is abduction.
Why?
Your Lordship, kidnapping is when a person is a minor or a person is of unsound mind and needs a guardian rule.
Even a major cannot be kidnapped.
He can be kidnapped
Then what are the ingredients?
If he is of unsound mind and he is unable to take his own decisions.
आप मुझे भी तो entice कर सकते हो. There is a word enticing.
Enticing.
Only abduction means using force.
Yeah.
That is only difference. 361 and 362. And BNS आप देख लेना क्या है. हम पुराने स्कूल के साथी हैं. Yes.
Your Lordship, if you are satisfied with the first arguments, I would like to proceed with the establishing whether there was criminal conspiracy between Akash and Suresh.
Which is the leading case from the point of this constructive liability? Leading case.
Lordship,
In all the judgments upon which you are relying upon, there is a reference with regard to the case Virender Ghosh versus King Emperor 1925, Privy Council, page 1. Why?
Need you also.
Yes. That is the basic authority on this point.
I would like to quote the case of Virendra Kumar Ghosh versus Kenyatta.
Yes.
It was held that individuals involved in a joint criminal act are liable for the consequences of that act, even if they did directly commit it, as long as there was a shared common intention. In the present case, Your Lordship, there was a prior meeting of minds.
Have you gone through the facts of this Virendra Kumar Ghosh case?
Indeed, Your Lordship.
Yes.
Should I state the facts?
He was waiting outside the post office. He was not in. He had not gone inside the post office. Neither he has snatched the bag from the postmaster. In spite of this fact, he has been held guilty under Section 3(5) Old 34 of IPC. Yes, continue.
In the present case, there was a prior meeting of minds and agreement between Akash and Suresh to commit an unlawful act of abducting Anita. Unlawful act of abducting Anita. Abduction in itself is an unlawful act. Abduction of a woman to compel her to marry an unlawful act. Your Lordship, it has been held in the case of State of Maharashtra versus Somnath Thapa. The Supreme Court of India emphasized the importance of corroborative evidence in proving a criminal conspiracy. The court stated while the prosecution need not necessarily prove that the exact date or time of the agreement, it must present evidence that strongly suggests the existence of an agreement between the accused parties. Your Lordship, in the present moot proposition, paragraph 7, it has been said that they both agreed to the plan of pressurizing her to come with them to the temple, on the condition that no harm will be caused to Anita and bottle of acid will be only used as a tool to threaten her for compliance. In the present case, Your Lordship, Akash has actively participated in the abduction the abduction that was attempted was demonstrated. Lordship, the council seeks 2 more minutes.
Conclude within 2 minutes.
Akash, again, the act of taking a woman against her will to force marriage without parental or personal consent is unlawful and amounts to abduction under Section 138 of BNS. Akash and Suresh agreement involving using fear or threat to compel compliance, even if the motive was marriage, a very sacred and very nice, very auspicious event. The fact that they wanted to use force or threat to compel compliance, the means were unlawful.
When the main conspirator is not under the bar or is not tried, whether a co-partner can be convicted solely?
Indeed, Your Lordship, he can be.
How?
Your Lordship,
मेन जब पकड़ा ही नहीं गया तो मेन कॉन्स्पिरेटर नहीं है हमारे पास तो एक साइड बायर को कैसे हम करेंगे?
Your Lordship, because under Section
He had not done anything. He had not attacked. He was the passerby at this stage only, and he was shocked what he was doing. How we can conclude that it was a premeditation of mind, and he should be liable for that. It was a conspirator. How we can?
May I answer?
The main person is out.
Your Lordship, Suresh is out. Secondly, in the present case, Akash knew at what can acid do.
He was not knew that he will throw it. According to the situation, it was a plan that we will make a threatening to her by showing acid. We'll make some allurement to her. But it was not in the mind of Akash. He will do, Suresh will do such thing. It is in the proposition. Then how you're connecting Akash with this conspiracy?
Your Lordship, to be safe, even if we take an illustration, simple normal illustration.
चलिए इसको छोड़ देते हैं, ये जवाब देंगे पहले.
You have concluded it?
Your Lordship, I have concluded with the prayer.
Yes, let us see your prayer.
Therefore, in the light of the facts stated, arguments advanced, and authorities cited, the respondents on behalf of the respondents of the counsels of the respondents humbly submit that the Honorable Supreme Court may be pleased to adjudge and hold that Akash is guilty of acid attack under Section 124, read with Section 3 Clause 5 of BNS, also hold that Akash was guilty under Section 70A and 87, which is read with Section 3 Clause 5 of BNS, hold that there existed a common intention between Akash and Suresh, hold that Akash's actions constituted a conspiracy with Suresh and or pass any other order as an honorable court may deem fit in the interest of justice, equity, and good conscience.
What's your good name, please? Vibhuti. Vibhuti, I have given all these things to you. I want that you repeat the prayer.
And before she starts, you said you are representing the respondent. You are before the, by way of appeal before the Supreme Court. You are appellant.
Your
You
state.
have filed the state. Crime is always against state. State is in appeal before the Supreme Court. You are not respondent. You are appellant.
And I apologize, Your Lordship.
Because हम चाहते हैं कि विभूति भी अपनी आवाज दे. Because this fact is going live on YouTube.
Yes, Vibhuti, what do you want to say?
विभूति आप भी बोले क्योंकि घर में सुनाना भी तो है कि मैं भी करके आई कुछ. बोलिए.
Yes.
Yes. माइक ले लीजिए.
Your Lordship, so I like to pray for the appellant side. Wherefore, in the light of the facts stated, argument advanced, and authority cited, the appellant humbly submits that the Honorable Court of Supreme Court be pleased to adjudge and hold Akash guilty of the acid attack under Section 124, read with the Section 3, subclause 5 of BNS. Hold Akash guilty under Section 78 and 87, read with the Section 3, subclause 5 of BNS, and hold that there exists a common intention among the Akash and Suresh, and hold that the Akash action constitutes a conspiracy with the Suresh.
Vibhuti, you are before the Supreme Court. You are in appeal, not before the trial court. Then you have to complain against the finding done by the High Court. Those findings are not correct as per the facts and circumstances of the case. You have challenged the findings.
Indeed, Your
By
Lordship.
way of the present appeal, you have challenged the findings of the High Court. Then you have to attack on those findings.
Your Lordship, High Court is itself is a bench of esteemed judges. And Your Lordship, that's why we have appealed in the Supreme Court, so that Your Lordship, by their guidelines, the High Court will get to know regarding that what kind how the Your
आप
Lordship,
इस चीज को विभूति हिंदी में समझा दो. What do you want to say?
Your Lordship, Supreme Court.
हिंदी में.
Indeed, Your
Be
Lordship.
comfortable.
Comfortable.
Yes.
Your Lordship, High Court is a supreme authority.
सवाल क्या था ऑनरेबल सर की तरफ से? आप क्या जवाब? पहले सवाल बताओ क्या पूछा?
Your Lordship, why we haven't filed.
Vibhuti, you are not in the trial court. You are before the Supreme Court. Trial court has convicted both of them. High Court has acquitted Akash. Yes. Now you are virtually complaining against the judgment passed by the High Court before the Supreme Court by way of appeal. You have to point out where the error has been committed by the High Court.
Your Lordship, the error has been committed in the common intention that they thought that Akash didn't view the asset on Anima. That's why they.
Then you have to make your case on the basis of the evidence which has been led before the trial court. The evidence is there. Both of them were present there, along with the bottle of acid. These are the material facts to point out.
Your Lordship. So, Lordship, so in this case, the Akash, Lordship, in this case, whatever finding the High Court in this case gave their judgment on the fact that the Akash didn't view the asset. He was just there, and he didn't view, so they acquitted him on that basis. But Your Lordship, in this whole scenario, district court had given a judgment regarding
Non-district court.
Sessions.
Court of
Court of
Sessions.
Session.
Court of
My
Sessions.
apologies, Your Lordship.
Yes.
The Court of Session have given their judgment on the basis of the common intention and on the basis of the Section 124, where it has been
Not on the basis of section, but on the basis of the evidence adduced
Evidence.
before it.
presented.
On the basis of evidence. First will come evidence, thereafter law will be applied, and thereafter the judgment will be delivered.
Yes. Lordship, in this case, the Court of Session have made their judgment on the basis of the evidence that has been presented before them, and that the evidence were that Akash was a science teacher. He knew what an acid would have hurted Anita to the extent if it is thrown on her.
Is it in the evidence? He was a science teacher and all.
Indeed, Your Lordship, it has been mentioned in the Moot Court that he is a science teacher.
Okay.
And it has been mentioned on para 2 of the Moot proposition on the first line that Akash is a science teacher and he was helping Anita with her studies.
Good.
And as a science teacher, he knew what an acid would do if it is thrown on someone, and it could. And when he was trying to marry her, to propose her, and Lordship, when they were dragging her to the temple and everything, at that time when Suresh threw acid on Anita. At that time also Akash didn't help her. He would have stayed there. He would have helped Anita, took her to the hospital. But instead of doing that, he fed away with the situation.
That's good.
Yeah, that's all. Yes.
With due permission of the honorable Prince, may I
Yes, yes, please. First of all, kindly tell us to whom you are representing. Yes, yes, yes. You are audible.
The council addresses the bench collectively as Your Honor. The council is here in the matter of the state versus Akash and others, and the council is representing the respondent in this case.
The respondent, namely
Akash and others.
Akash. Yes.
If the honorable bench is well versed with facts of the case, may I
Yes, yes, please come.
Your Honor. For issue number 1, that whether Akash is guilty of acid attack under section 124 read with section 3 subsection 5 of BNS, the respondent respectfully submits that section 124 BNS penalizes voluntarily causing grievous hurt by acid with life imprisonment or a term not less than 10 years and fine. It necessitates specific intent or knowledge, Your Honor, to cause grievous hurt. A burden of persecution must prove beyond.
Yes, yes.
Mic is very sensitive.
It necessitates specific intent and knowledge to cause grievous hurt. A burden, the prosecution must prove beyond reasonable doubt. Section 3, subsection 3 of BNS. This section imputes joint liability of acts done by several persons in furtherance of their common intention, stating when a criminal act is done by several persons in furtherance of criminal common intention of all, each of such person is liable for the act. Your Honor, it requires a pre-arranged plan and shared intent to commit the specific offense elements absent in Akash's plan. Your Honor, specifically it is contended that first, the absence of mens rea absolves Akash of liability under section 124. Secondly, Your Honor, no common intention existed with Suresh under section 3 subsection 5. Thirdly, Your Honor, the chain of circumstantial evidence is irreparably fractured. Fourthly, Akash's non-violent intent negates actus reus for acid attack. And fifthly, Your Honor,
Case is not based upon the circumstantial evidence. Evidence is there. Victim is there. How you can say it's a case based upon the circumstantial evidence? How can you say this thing?
Your Honor, it says that the chain of circumstantial.
It's not based upon the circumstantial. Their presence was proved there on the spot.
But there were circumstances on the basis of which it
There
was
is
proved.
difference. Counsel, there is a difference in circumstantial evidence and the chain of circumstances. Chain of circumstances is something different. कि मैं यहाँ से चला वहाँ गया वहाँ से आगे chain बनी. Circumstantial evidence means there is no direct evidence. That was the contention of lordship.
Alright.
Right?
Yes.
There is a quite difference between circumstance. When the victim is there, she is stating in the court that he had done this thing. That is direct evidence. That is not circumstantial evidence.
And you are taking the benefit of this fact that the main accused has not been arrested and he has been expunged. Does it absolve you? from the liability which has been passed against you.
Are you taking the benefit of Suresh?
No, Your Honor,
Yes.
no, Your
Yes.
Honor.
Yes.
No, Your Honor, in the present case, it clearly shows that Akash was not having common intention. Talking about section 3, subsection 5, which clearly shows that common intention is very much important. And in this case, as it was agreed on the basis,
Question of common intention is question of law or question of fact?
section 3, subsection 5, which talks about common intention.
That is definition there.
Yes, Your Honor.
Yes.
All right, Your Honor, so it is a question of fact.
It's a fact. Yes.
Yes, Your Honor.
Your presence is there.
Yes, Your Honor.
You both were there. You along with this Akash were there along with the bottle of acid. A discussion had taken place between you and main accused Akash, who since now been absconded. He want to drag that lady, that girl, into the vehicle.
But Your Honor, conclusively, intent was not there to throw the acid of Akash. It was clearly based on the contract, kind of.
Also, it was not a plain water; it was acid.
Yes, Your Honor.
You were there with acid
Just because there was presence
in
of
the downstairs of a temple, not in the factory, not in the laboratory.
Yes, Your Honor.
Yes.
But there was agreement on that no harm will be conducted on her,
Yes.
which was clearly said. On that basis only Akash agreed to this performance, not otherwise. So it clearly shows that there was no common intention. Moreover, Your Honor, he was in love with her, which clearly shows that he was having no intention of hurting her, not even with acid.
There is a concept in the law, transferred malice. What does it says?
Like, for the intention. Ultimately, the intention
Transferred
is.
malice. Accused intend to kill A, but unfortunately he shot B. Then he can't say, my intention was to kill A. Now you can't hold me liable for the murder of B because I was not having the intention to kill B. I was having intention to kill A only.
In this case, Your Lordship, there was no intention of hurting her from Akash's side. May I proceed, Your Honor?
Because
Yes.
what you have prepared, you will not hear that thing. You are in the Supreme Court at this stage. So